I'm Buck Malick. I'm the chair of the St. Croix County Zoning Board of Adjustment. I'm calling the meeting to order because it's June 26th, 2025. The clock on the wall says it's 8:31 right now. We're in the St. Croix County Government Center, room 1400. This is the time and the place that were publicized, I believe at this point, were publicized as a place for the June meeting of the Zoning Board of Adjustment. I'll ask the other members of the Zoning Board of Adjustment to use their microphones and introduce themselves. And I'll ask the members of the staff of the county staff of the Community Development Committee to introduce themselves. That'll do some things for us with the audio system, as well as give you the names and them a chance to clear their throats. I reside in the town of Hudson, Wisconsin. We each have to live in a different town. Mr. Peterson, you're next, please.
Dave Peterson, citizen member, town of Kinnickinnick.
Steve Smart, Hudson Township, alternate non-voting member.
Joe Miller, citizen member, town of Hammond.
Greg Telejohn, District 14, County Board Supervisor, representing Aaron Prairie, a little bit of Warren, and Richmond Township.
David Nickham, citizen member, town of Baldwin.
Mike Wozniak, land use administrator for the county.
Jason Cheezick, community development director.
Christine Hines, county clerk.
Thank you all. We have to the right of you, audience members, against the wall, a sign-in sheet. We have dispensed with administering an oath to witnesses when they speak to us. So instead, we ask you to sign over there. And there you are taking a written oath that any testimony you give will be the truth. So if you think you may speak today on either of these hearings, please sign over there and get it handled. If you don't sign initially and you later change your mind and decide that you're going to step up and speak at the podium, then we'll have to wait for you to go and sign at that time. So there's no penalty for signing and then not speaking, but there is for delaying it. We have two variances to decide upon today. Our process is typically to listen to a presentation from the zoning staff accompanied with visuals, then to hear from people who are advocating for the application, who want to see the application passed, then from those who are opposed to the application, and lastly, to those who are not necessarily for or against, but have some point that they think the board needs to hear in order to make the best possible decision. We can deviate from that process, but that's kind of our template. The board may have questions, so anybody who steps up and speaks should wait just a moment at least to see if there are questions from the board members before resuming their seat. We typically go through a hearing and then move on to a decision, although sometimes we do both hearings and then take both decisions in the second phase. If you've seen our agenda, you can see it's formatted that way. Except for Mr. Telejohn, who was elected by the voters, the rest of us were appointed by the county board. That's why we call ourselves citizen members rather than elected members. Two of us live in the town of Hudson, and as you noticed earlier, one is acting as an alternate today, so that if I have a heart attack in the middle of the process, he can step in. Ready, Steve? Don't do that. Yep. So when I retire, presumably he'll step forward and continue on. With that, we have one little item of administrivia, I guess I'd call it. Minutes of our previous meeting, which was dated April 24th. Board members, do any of you have edits for the minutes of the April 24th that were given to us in draft form, or shall we deem them approved as is? Seeing nothing, they will be deemed adopted. And we're ready for the first of our public hearings. I assume it's the Blahnik matter. Mr. Novak, you have the floor.
Yes. Good morning, Board of Adjustment members and those here, the public and the applicants and any of their representatives. Our process in reviewing these is staff run through the staff report that was prepared for the item. And then the Board of Adjustment holds opens public hearing, takes comments, and then when that is completed, we either distribute and or display a draft decision document that staff have prepared for the Board of Adjustment to consider to guide their action, establishing findings of fact, some conclusions of law, and an action for the Board of Adjustment to consider taking on the item. Bear with me just a moment while I pull up the staff report here, if I can get the mouse to work this morning.
While you're doing that, I realized that I forgot to verify that this meeting was properly noticed and published. Is there anybody who believes that there was some defect in the way in which this was published in the newspapers? There rarely is. In my 19 years of doing this, it hasn't come up, but we always ask. No, so we will again proceed on the assumption that this meeting was properly noticed and published, and we are authorized to take action today.
Very good. I'll run through the staff report now. So this first request for consideration of the Board of Adjustment is a variance request to a shoreland ordinance, or Chapter 16, of a setback from the ordinary high water mark. The request from Brent Davis and Maria Blahnik at 1965 110th Street in the town of Star Prairie is the request is so that they're interested in adding an attached garage to their dwelling, and basically the only place they really can add on, or even they're very limited, even though they have a 40-acre parcel on extremely limited and really not able to build a detached garage that would be accessible either. So that's the really the reason for this request from the applicants. And as is customary, we in the packet for the Board of Adjustment, we made the staff report available and the variance application that was submitted. The applicants are, again, requesting to construct a two-car 30-foot by 24-foot garage adjacent to the north face of the existing dwelling. The request is to reduce the current ordinary high water setback from a navigable pond from 75 feet to 56 feet. And there's no garage currently existing on the property. Now, one thing I note on this is staff had a lot of interaction with the DNR on determining where that ordinary high water mark setback should be. And our view from a staff standpoint is DNR had a very conservative approach in terms of setting it, 56 feet from the current dwelling. I think the water's has been at a high level, but be it as it may, that was the determination made. And just to share a little more information about the property, it's in an R1 residential district, again, in the town of Star Prairie. There are a couple ponds that fall under the shoreland rules, and the dwelling kind of sits right in between the ponds. And even though it's a 40-acre parcel, the rest of it's not really accessible to access with a driveway for a garage. And it's in two parcels under the ownership, a 6.5 acre and 33.5. Actually, those are parcels to the north, and as indicated on this slide, a 5-acre residential parcel and some undeveloped land to the south, and a 40-acre parcel to the west. So it's pretty rural residential in character surrounding this. And this site plan kind of indicates the layout of both the existing dwelling, where the sanitary system area is, and where the proposed garage addition is requested. I note that the existing house and septic system are positioned between the property line and steep slopes leading to both ponds. A licensed plumber confirmed there are no alternative locations for the septic drain field, and any other alternative location would encroach on critical infrastructure and require extensive grading into slopes of 25% or greater. So there are definitely physical constraints on this property that limit where a garage could be constructed. Further, I'd note constructing a garage on the west side of the home would not be feasible due to the placement of the septic area. Constructing on the east side of the home would not be feasible due to a lack of driveway access, steep slopes, and close proximity to the ordinary high water mark. And the area immediately south of the residence would require extensive excavation and retaining walls. The existing propane tank would also need to be relocated. Just to illustrate what it would look like, this is some virtual imaging of what the garage addition would look like added on to the existing dwelling. And this is a view of what it looks like now from the north, looking towards the house from the north side, and a couple actually view from facing from the southwest here at pardon me. And you can see where the driveway comes in and where that garage would be placed next to the abutting, attached to the existing dwelling where these vehicles are parked here. Just some additional photos of the site. Kind of the proposed garage location here. And we've got photos. Again, there was a lot of evaluation and on-site analysis of where that ordinary high water mark would be, and noted on here in this photo. And there is a pretty substantial tree cover that separates the dwelling site from the pond to the north, and it's screens it pretty well, and there really wouldn't be a any significant change in terms of the aesthetics. The garage would be a one-story versus the two-story house as well. The town of Star Prairie has considered this item, and they recommended approval due to the unique features and constraints of the lot. And as we have our customary slide outlining applicable statutes and criteria for consideration of a variance. I won't run through all these, but if the board has any questions, some of these, there have been, I would note for your interest that these are from our shoreland ordinance. There are specific criteria spelled out in there. And then there are the three criteria established through a ruling of the Wisconsin Supreme Court that we take into account for consideration of any variances. Those relating to unique property limitations, applicant proving unnecessary hardship, and no harm to the public interest. Now, I would note, besides the comment recommendation of approval from the town, I have verbally spoken with a couple abutting property owners, and they just had questions about what was being proposed, and once it was explained, neither of them had any issue with the request, and I believe the applicants have had some contact with neighboring property owners as well. And if you have any questions for them, they could probably speak to that. As I indicated, we have a draft decision document. I'll allow you to move forward and either ask any questions of staff or open the hearing. And when that's complete, we can pull that up, and I can distribute hard copies if you'd like as well. And at that, I'll stop my remarks and be available for questions.
Yes.
Isn't there a federal law about, does government control every mud puddle or every pond, or isn't there some law? Or
The law you've cited, Mr. Wozniak, is the law pertinent to this. There is no federal law that imposes any harsher requirements than the one we have before us. Is that a true statement?
No, I mean, if there were, for example, if there were wetlands identified, that would probably be more subject to regulation by the DNR. This isn't a subject. These ponds are not subject to like scrutiny by the Army Corps of Engineers, for example, as might occur on the river, on the St. Croix River, just as an example.
Well, you
So it's
say
shoreland and shoreland rules that are dictating that setback from the ordinary high of 75 feet, which is what you're being asked to make an exception to.
Yeah, it's a navigable pond, as you say in the staff report, which
Correct.
means it can float a canoe or a log in historic times, but under the Northwest Ordinance Act. But there's no stricter federal law that applies, Mr. Nickum, than this. Any other questions of the board?
Was there discussion on water mitigation and runoff?
Yeah, let me, I can speak to that. Because the project is in a shoreland area, there would be a follow-up land use permit required. And typically, for something like this, the concerns with the land use permit would be revegetating any disturbed ground that isn't going to have structure or driveway on it, and management of stormwater runoff. So, we'd be looking at where is the roof drainage and driveway drainage being directed, and would require, as appropriate, measures to detain and filter the water that runs towards the water feature so that it doesn't affect the water quality of the pond.
So that it doesn't pollute the water,
Correct.
in short, yes. All right. Would the applicant or people speaking on behalf of the applicant like to be heard now? This would be your opportunity if you wish to say anything about this. Good. Are you, you're the mister of this, I take it?
Yes. My name is Brent Davis. You know, we've thought about it, very thoroughly, and I'm very nature oriented myself. I want to make the smallest footprint, possible in disturbance. And, I really love my new property and my land. We're new to this area since January, and it's really awesome. And, we have a what do you call Jen? What's her title? We have like a landscape specialist that specializes in nature and making things natural and preserving stuff. We have her on as part of this if we actually get to build the garage. For sure, I will not want to disturb the nature of anything. I have as good as intentions as I can possibly think that I could have to keep everything nice but still have a place to have a garage. And I was coming up to ask if any of you had questions.
Anybody have a question for Mr. Davis? Mr. Nickum?
First of all, thank you. I walked over my own feet and fell down and exploring his property. And in kindness, he helped me up and was concerned about my health, but the only thing that got hurt was my pride. And I thank you for that.
You're
On the
very
fill
welcome.
side, are you hauling in fill?
No, there shouldn't be any fill. It
On the
should
low
only,
side, what are you gonna do about leveling the garage floor?
on the garage floor should be at the level of the current driveway.
It doesn't reach out over into the bank, into where it drops off?
No, we won't be moving the driveway out any further. Like the current driveway that is there, it'll just, of course, that'll probably be disturbed and have to be, redone, but it'll be just exactly as it is now. That driveway comes up and, so the house structure is here. The driveway comes up like here, and then there's parking space that's where the garage is currently going to be. That's already paved, and that's just where the garage will sit. So that driveway pull in and out. Where you parked that day, that driveway will just it'll be just pretty much like it is right now.
Let the record show that Mr. Wozniak is pulling up one of the pictures that demonstrates that the area is already impervious, essentially.
Yes, so you can see in the picture on the left, sorry, got a little close there. The picture on the left, to the left of the house there where it's already paved. And the picture on the right is the rendering of where the garage will be. That driveway that's in front of that garage right there is the current driveway. That's not a rendering. We only put the garage itself on to an existing picture. So the impermeable surface that you're seeing there is what's currently already there.
On a related point, as we had this earlier discussion with Mr. Wozniak about the land use permit and its requirements, given that there will be runoff from the garage roof, and concentrated runoff can lead to erosion issues, very likely your land use permit will have some sort of requirements that might call for a rain garden or, I don't know, some kind of slope management, special kinds of vegetation that are good at keeping the soil in place. You're nodding your head to indicate this is no surprise to you, and you don't object to that sort of thing.
No, that's what our landscape expert, Jen, she's a expert in land management and water runoff and invasive species removals, and she's went over multiple ideas and plans as far as rain collection and water runoff, ideas, French drains. There's lots of options that we can go with, and with the approval from the board, she will be, part of this project, making sure that our runoff does not cause any, I don't want the side of my hill eroding off, and then I have, a major problem there. I'm planning on making sure that does not happen.
That's great. I feel like I ought to make a statement here that all of our decisions are made as if anybody could be the applicant. It wouldn't necessarily, I mean, we'd need to make the very same decision if the applicant standing before us wasn't you, but was an axe murderer or a tree hater, because our decisions have to be made for perpetual results. In other words, you might be run over by a truck on your way out of here back to the place, and somebody else moves in, and yet our decision has been our decision, So when you think about it, it makes some sense that as wonderful as your intentions are, and as it was commented on by Mr. Nickum, they can't factor into our decision. We will have to make an objective decision, and our requirements in the conditions of the granting would be the same even if you had the intention to damage the property as much as you could possibly get away with. And I'm not imputing that to you,
I
but I'm
understand
just
what you're
saying that's
explaining, for
the
sure.
way we have to work. The Supreme Court tells us so. It appears to me that one of the factors in our decision, there are these three factors that we have to find, and one of them is there would be no harm to the public interest. And of course, water pollution from the runoff, as we've been talking about, would be a harm to the public interest. So we're dealing with that water quality issue. The burden of persuading us is your burden. If you don't persuade us that you've met the three conditions, we can't give you a variance. But it seems to me that one of the factors that's favorable to your application is the relatively low residential density that's possible on this 40 acres. Are there any other sites on this 40-acre property that you think could be suitable for a house?
Not without very, very extensive, let's see if I can,
Probably they'd need a variance also, right? Given the way the contours of your property are, and so much of it is actually the ponds.
okay, see, you guys can see what I'm seeing right here?
Yes.
So you got this pond here, which then runs all the way, and this is kind of a pond, I guess you would call it. It's wet. It's not quite as full as these, but it's full of grass, is why it doesn't really look like water. So there's a very serious water through to this, and then right through there is the water through to this, and then right through here is the water through to this. So all of these are connected. So to get from this road to anywhere back here is you know, to put a road through there would be, you'd have to build a bridge or something across all this. And then this is extremely steep right here. So to get back here, you would have to have some sort of access from some of these other properties. So I don't believe that anywhere in this in the future, there would be any housing.
That's the point I was inquiring about, and that being the case, you know, there'll be one house on 40 acres.
Yes.
And the probability of that one house polluting the water and therefore harming the public interest is a low probability. Hard to foresee how that could come to pass. All right.
I would
others
also,
have questions?
sorry, I'd also like to add that the proposed garage area is all currently impermeable surface currently, right now. So like, you know, as far as runoff, in my opinion, there wouldn't be much more runoff with a garage there versus asphalt there. It's kind of the,
Yep. What
it'll
do you
be-
think, what do you think is unique about your property that justifies a variance?
okay, so,
Is it the slopes and the fact that so much of it is covered by water or wetland and therefore
yeah,
there's only one building site on the whole thing?
yeah, this area that the house is on is basically the only flat-ish area on the whole property. You can see this line right here is actually my property line. My property line does not run to the road. I actually have a easement for this part of the driveway on the neighbor's property. So the distance from the house to the property line is very sloped down here, extremely sloped down in the back. There's like no way to go out the back. And then, you know, like this way up here is also extremely sloped up and heavily wooded. And to get over to here, we'd have to cross our septic tank, and that's a no-no also to, you know,
Certainly.
to drive across, you know, put a driveway or something and try to drive across your septic system. That's not gonna happen. And so, yeah, that's my uniqueness is I have no way to that back part of my property to build anything. And even if I could go through the extreme of getting some special variance to get across all them creeks and water features to get back there, to get up to the back where there would be any place to put some sort of garage, would be, you know, a quarter mile from the house. So also, you know, not really feasible.
Understood. I think the board will likely find that it's an unnecessary hardship these days not to be able to have a garage next to a house. It's come to be an accepted thing in this county that, you know, just as houses have bathrooms and houses have bedrooms and so on, they have garages. And two-car garages are not excessively large garages. So to not be able to have that would generally be perceived as an unnecessary hardship. So we don't, unless somebody else got another question for you, I think that takes care of that. Is there anybody else who wants to speak in favor of this application? Okay, apparently you two are the only ones concerned about this application today. Although, is there anybody in the room who wants to speak against this application? Or lastly, not necessarily for or against, but wants to make some comment or argument or point of view or give us a fact? No? Okay. I'm on the verge of saying that we'll close the hearing then, meaning we will no longer take any testimony or any documents. We would move forward. And in this one, I guess we could go right ahead towards a decision and thinking board rather than have the other hearing and then try to remember what the first one said, so on.
Thank you for
So-
you guys' time.
Thank you, Mr. Davis. Stand by, but you won't get a chance to talk again. So I declare the hearing closed now. And members, let's get a general sense. Are we moving in the general direction of granting the variance? Show of hands. Yeah, I think so. That's where I was going to as well. So, Mr. Wozniak, you're handing out proposed findings of fact and conclusions of law that would lead to a grant of the variance, I take it? You're anticipating we would see it that way?
Yes, Mr. Chair, that's what I'm doing. And as is customary, the findings have basically the relevant information about the property, and they note the town's recommendation as well. I won't read through them, but can explain if you have any questions on those. And as we customarily do for conclusions of law, we basically put statements in reflecting on the criteria that the variance is subject to, and both the, as I alluded to earlier, the criteria set forth in the shoreland ordinance for granting of a variance, as well as the criteria, the Supreme Court measures as well. And I think it's consistent. Staff's view is this request would be consistent, that there is enough of a demonstration of physical conditions on the property that are very limiting. I would add also, just for your interest, that staff did look extensively at the options, if there were any, for constructing a detached garage versus an attached garage. And as the applicant had explained, that's problematic as well on this property. And so their proposal seems to make the most sense. And if I get down to the action that we've included in this draft decision document, it would be a action by the Board of Adjustment to approve the variance to place an accessory structure. I should say, in addition to the principal structure, maybe this should be slightly adjusted, Mr. Chair, because an attached garage is considered part of the principal structure rather than an accessory structure.
So that would be in point number one?
Yes,
At
or
the
in
end-
the,
At the end of the first sentence? to build-
correct.
And we just say to build a garage,
Yes.
an attached garage. Can you make that change?
That would work just fine.
Everybody see where we are on the first page? The second number one, under literal enforcement, unnecessary
and-
hardship.
And down in the
garage.
decision, that first sentence, I think it references accessory structure. It could say attached garage. Just so we're accurate here in how that's looked at. And then we address other recommended conditions for the variance, that their proposed addition, attached garage, be in accordance with their submitted site plan and supporting information, that they would be subject to obtaining a shoreland land use permit to address grading, filling, erosion control, and stormwater management prior to initiating any site work or construction of the proposed garage. And we reference that setback of 56 feet from the ordinary high rather than the 75. And our customary requirement that any applicable local, county, state, or federal permits be required. What would be most applicable here would be a building permit from the town of Star Prairie. At that, I can field any questions you may have regarding this document, or if you feel there's anything that should be added or amended, that's at your discretion.
Board members, with that one change to call it an attached garage rather than an accessory structure, looks good to me, but I don't want to speak for you. But does anybody want to make a motion to accept it this way as the staff has written it up with that one little change, for example, or something else?
I'll move that we approve the variance as presented by staff, amended.
I'll second that.
Thank you, gentlemen. A motion and a second. Is there further discussion, debate, amendments? I'll call for the vote then. All in favor should vote aye.
Aye.
All opposed should vote nay. That's unanimously approved. We'll follow along that language. If you get a chance to modify the thing before I leave today, I'll sign it today, Mr. Wozniak.
Very good.
It's now 9:11. I don't feel a need for a break, board members, but do any of you? If not, we'll proceed to the next matter.
Thank you, Mr. Chair. I'll follow up with this one. Greg and Dana Bauer are requesting a variance to reduce the required setback from 50 feet to 10 feet from the right-of-way along the east property line in an R2 residential zoning district pursuant to section 15.231 of the St. Croix County zoning ordinance. The property affected is located in the northwest quarter of the southwest quarter of section 21, town 30 north, range 18 west, town of Richmond. Address is 1436 112th Street, New Richmond, Wisconsin, and a proper Class 2 notice was published in the Star Observer the 2 weeks before this hearing today. So the applicant has owned the property since the late 1990s and wants to begin building a house on the property. The applicant, and that has some slopes on the property that makes them want to request a variance to the right-of-way of the road from 50 feet to 10 feet. This here is the original CSM map, and the applicant's own Lot 3 right here. The cul-de-sac for 112th Street currently stops right here. You can see when this was platted, though, there was a 33-foot highway and that on each lot coming down, so that would be the right-of-way width there. There is a non-navigable wetland slash pond here in the middle of the parcel, and as you go south, and that there gets to be more and more wetland, and that would be down here is 10 Mile Creek, and that is owned by the DNR land. Or it's owned by the DNR, it's DNR land. So this here is a picture of the proposed site for the new home. It's the flattest part on the property compared to the rest of the property. Not a lot of old growth, it's all pretty young trees and saplings. This is from the proposed building site towards the south, so this would be towards 10 Mile Creek. You can see it slopes generally down. This would be looking from the proposed building site almost to the west at that non-navigable pond wetland area, kind of in the background here. Looks like some younger box elder trees and some sumac for growth. So this would be the right-of-way of 112th Street going towards the south. It was an old farming driveway to get down to the DNR property. This area here would be also used in the future for anybody that wanted to access the property of the DNR or 10 Mile Creek. So the town doesn't have any intentions of building this as a road, but they want to retain the easement to be able to access that property and that for the public. This is probably the best picture of the whole thing. So the house would be 43 feet from the east property line here. The pond is here. There's about 14 feet of elevation drop down towards the pond area. This here shows the wetland marshy area really well here. You can kind of see that boundary clear. And then there's possibly going to be a new shed in the future in that area. This map shows the slopes of the property, so you can see the tan color is in that like 12% slopes. The red is over 25% slopes. So there's a lot of slope here dropping to the south, and that a little bit of red slopes, and that around the pond, and then this generally flat area where they intend to build and have their sewer system. And then as you are all aware, the same three criteria applied to this application as the last one: the unnecessary hardship, property limitations, and then the harm to the public interest. So that summarizes the staff report. The town also is supportive of this variance request. But they will retain that roadway easement and that going to the south.
Board members, any questions for Mr. Chiza?
There are two posts with red signs on them, or was there a road through there at one time, or why is that?
That was on site.
Yeah.
I haven't been to this site. Mike, do you have any information on that?
Microphone.
Pardon me. On the site, there is a driveway that runs across the north part of the site to access another lot, and a family member owns. And then historically, the way it's been, yeah, exactly, that where Jason is identifying that. And then basically along that east edge of the property, that where that extension of 112th, the farm road, existed, at one time there was some kind of bridge over 112th. The town has been very clear, a town of Richmond, that there isn't, it wouldn't really be feasible to construct a public road, and they have no intention of constructing a public road along that east boundary in the future. But they do want to retain the right-of-way. So, and I haven't been really party to it, but there had been discussions between the town and U.S. Fish and Wildlife about access to the property, to the south, on that north side of 10 Mile Creek for the public to be able to use that. I can't really speak to that. That's really between the town and U.S. Fish and Wildlife, and maybe the abutting property owners. But as far as this goes, the town was clear they had no objections to this variance. They support it. So that's what we can add at this point.
Well, they
So the
have,
long way around is those are probably surveyor's stakes related to some other idea or some other question, some other activity, like the driveway.
We took a bunch of pictures, but I don't know if I can recall just where the stakes may have been.
well, it was just interesting because it looks like was a road through there and they blocked it with these two markers, but I don't
Mr.
know.
Chair, that might be a good question for the applicant. They might be able to fill in a little bit on that.
Yeah, yeah. Wow. Yeah, they might. Mr. Miller?
To the best of your knowledge, has the applicant included everything that they're going to put on this property so they don't have to come back next year and request a garage or anything like that?
To my knowledge, yes.
We're, one thing could I just add that we're not so much with this request, we're granting a variance to the setback for, from the right-of-way. So instead of the required 50, it would be to 10. You could limit it to just the structures noted, but to be honest, they're limited on the amount of buildable area they have. So Mr. Bauer could probably explain that, you know, at a point, he and his wife will max out how much house, driveway, and shed and sanitary system they can fit in the area that's suitable for them.
I had a call from the U.S. Fish and Wildlife Service representative in this area yesterday who had seen this application, and before I could stop him, he told me they had no objection. You noticed, of course, in the file in the staff report that the Fish and Wildlife Service manages this access, uses this access as a way for the public to get to 10 Mile Creek and to the land that is owned and managed by the St. Croix Wetland Management District of the U.S. Fish and Wildlife Service. And so Chris said that their plans are not impacted by this. It didn't matter to them whether the home and things were set back 50 feet or 10 feet. So if there were stakes out there impeding progress along this publicly owned road, then they should be removed, and the Fish and Wildlife Service will take care of that in the process of their making that available to the public to use. So we of course are sensitive on this board to ex-parte contacts where interested parties reach some of us or any of us when possible opposition viewpoints aren't present to hear about it. So I want to be sure to mention on the record that I did hear that bit of input. Any other questions for Mr. Cheesit? Okay. Let's hear from the applicant or their proponents, if any of you wish to speak. What we would, of course, be most interested in is if you disagree with the idea of approving this application, if you think there's some reason to say it differently or put in conditions or the like. Okay, I recognize venerable and respected attorney Sam Carey here, and he was about to get up when I continued with my second sentence there, so welcome, Mr. Carey. Usually when a lawyer appears, we figure people are trying to pull the wool over our eyes, but we could probably make an exception for you.
Well, I don't know, maybe I should exit right now, I'm not sure, but thank you. I think that the application packet lays out things pretty clearly. We've had some history on this, trying to help the Bauers resolve a way to have a suitable building site for their retirement home, which has been their desire for a long time. One would look at this and say, well, you bought this lot with these characteristics way back, so maybe you have imposed the hardship by buying the lot, knowing these restrictions. And I think they provided to you what's important, I think, in an exhibit to the application. I think it was labeled Exhibit A. They provided to you a history of where things were at when they bought the property. And that history would indicate that there was a clear indication that this platted town road that was unopened, unimproved, and not used was going to be vacated. And it just didn't happen as anticipated when they bought the lot. Subsequently, they made efforts to see if they could get it vacated. And for the reasons stated, because of the Fish and Wildlife involvement to provide access to the 10-Mile Creek, the town has been reluctant to vacate. And so they're now stuck in this current situation. Yeah, thank you. They're now stuck in this current situation with a very, very limited area within which to build if the setback is not, the setback variance is not granted. And I believe that those setback requirements as it relates to town road right-of-ways anticipate that the road is either in existence, traveled, used, or it's going to be traveled and used. And that's why there is the width of a setback for town roads. That's not the case here. This thing is, like I said, been platted for a long time. It's not going to be used. The town has said it's not going to be used. It's simply a pathway for Fish and Wildlife to get, to provide access to the public, pedestrian access by the public to the 10-Mile Creek. In terms of any questions that you might have about the physical characteristics of the property, although I've been out there maybe twice, I think Greg Bauer would be the best person to answer those for you. If you have any other questions, I'm glad to field them.
I can't help but observe that this is a somewhat unusual example of people wanting to be close to a public access. In many times when a government body is thinking of establishing a park or a trail, the neighboring property owners say things like, oh, the value of our property will decline, will be less because of the public going by and litter and noise and all that. Studies that I have seen in other contexts indicate that's not the case, and after the trail is eventually built, then people begin to list it when they go to sell their house as an amenity, that it is adjacent to a park or a trail. Here we have homeowners who embrace the proximity to the trail, who want to be as close as reasonably they can, 10 feet. And I also would observe that when we're looking at the three criteria for a variance and we're looking at the public interest, we have to think about why do we have setbacks from public roads? And you, of course, have said it right, Mr. Carey. We have setbacks because it relates to things like children and dogs running out into the road and traffic, or traffic accidents coming and hitting the house, or noise problems going both ways, distractions, flags that distract the drivers as they go by, balloons bouncing across the road. All of those are in the context of regularly and well-used roads. So this is not that kind of instance. This is a dead end. It would require the building of an expensive bridge to bridge 10-Mile Creek down there. It's extremely improbable that that is ever going to happen. So with respect to criterion 3, the possibility of harm to the public interest by letting this house be built more closely to the nominal roadway than the ordinances allow, that appears to be a criterion that is satisfied in my view. And of course, I don't speak for anybody else at this point, just for myself. The unique property limitation, this is a 10-acre site, roughly 9.477, including the right-of-way, according to the surveyor's plat. And it appears that there's only one possible building site and that steep slopes really constrain even that possible site. So if we look ahead 50 years, there's still only going to be one house on this 10-acre lot, it would appear. To not allow any home to be built on a 10-acre lot is inconsistent with the general theory of our zoning, or generally when we have zoning that is residential zoning, the idea is there'll be a house built on there, at least one house, and maybe on many lots there can be several after appropriate rezoning to lot sizes. And is this a unique property limitation? Is it because of the property or is it because of the people? Mr. Carey has alluded to that. There's nothing the people have done to this property that causes the limitations. They haven't done anything to it at this stage, except, I guess, grant an easement across the top of it, the northern edge, to get to the adjacent property to the, that's north and that's south, to the west. Yeah. That's where I'm at. Are you agreeing with those points, Mr. Carey?
Yes, I do, Mr. Chair. Thank you for articulating those, yeah.
Okay, board members, questions? Anybody else want to be heard in favor of this application? Do the Bowers particularly want to be heard? Mr. Carey, you can control the flow of traffic of your clients as you wish.
Thank you. Greg, this is Greg Bauer.
Hi.
Mr. Bauer?
Thank you for your time, the board and Mike for helping me on the application. This has kind of been a long, drawn-out scenario for many years, and we thought a few times we had it all resolved. And it came to the point where in order to, in my opinion, in order to be able to develop the property and put a home on there, the variance application would have to be put in with the county. So we didn't think that was gonna be even a situation that we were dealing with when we first bought the property, because the old road right-of-way was supposed to have been discontinued. We have for many, many years tried to resolve this issue. Myself and the bordering property owners, we've agreed to easements. We have agreed to sell property to U.S. Fish and Wildlife. We've agreed to try to provide property for U.S. Fish and Wildlife to the south to access their land through possible grants from like Ducks Unlimited and stuff. My son and myself were very active with Ducks Unlimited. We love the property. We bought the property because of its country aesthetics. We don't oppose hunting. We've tried to get an access through there, and we just were not able to dot the i's and cross the t's, in my opinion. I don't want to get into that whole situation. As far as the history goes, you've got some of the history in my application. I believe the 3 signs or stakes that were presented earlier, I think those are the end of the road signs that the county put in when the road and the cul-de-sac were put in. And yes, at least one of those will probably have to be removed when U.S. Fish and Wildlife goes in to develop a trail down to the south. So I hope that answers the question that came up. There has been, the lot had been surveyed. My neighbor's lot just changed hands. There's a new owner for that within a year ago. Some of those stakes with the signs and the flags on them may be surveying stakes. My neighbor has to put in some driveways for compliance with his new lot, I believe that that was recorded with the county within a few months or weeks from now, so. Does the board have any questions for me?
No, I don't think so.
Did I ramble on too much?
No, it is all perfectly appropriate. Yep, good background. Does anybody else want to speak in favor of your application? No? Is there anybody in the room who opposes this application and wants to be heard? Anybody who doesn't want to declare for or against but wants to be heard, has something to say that'll help us make a better decision? No? Is there anything we need to know that we don't know, board? I didn't expect controversy. I told my wife I'd be home early. But that doesn't mean I won't stay, for whatever is needed if somebody wants to create a controversy. That's not new here. Well, then I think I will declare a closing of the hearing. Thank you, Mr. Bauer. Thank you, Mr. Carey, for your testimony.
Thank you for your time.
Yep. So we won't hear any more testimony, and we won't take any more pieces of paper and documents, except now we'll move forward towards a decision. And do you have something already worked up, Mr. Cheezit, on the theory that we would probably be granting the variance?
We do, Mr. Chair. We've got the findings of fact and conclusions of law here, basically with the property size, the address, and where the property is located, that it's zoned R2 here currently, that they're requesting a 10-foot road or street setback off from the right-of-way instead of 50 feet as per Chapter 15.231. The variance will not be contrary to interest because they have sufficient separation from adjoining properties, and the fact that the town has approved of this setback and they have no intentions on building a road in the right-of-way that they have, or that easement that they have on the plat. Unnecessary hardship, they've got a 9.8 acre parcel. It does have some natural features that make it unbuildable for the most of that property size, like the non-navigable pond and the wetlands on the south side of the property. 10 Mile Creek is also down to the south on the adjoining property.
Let me just stop you before you
Sure.
get too far. I don't understand why the draft calls it 9.8 acres. The certified survey map shows 9.477, including the right-of-way. Has something changed over the years? Have they, this isn't riparian, so it couldn't have had accretion to it. I see down in the right-hand corner there for lot 3, 9.47, that's the gross, and 8.2 is the net. Neither one is 9.8. Is that just a typo, or is there something that
I think we
did
should go with
change?
9.477
Do ya?
because of the CSM.
The only explanation, Mr. Chair, I could have is sometimes the tax records, there's a discrepancy between what they note and what the survey documents show sometimes.
Oh, my goodness. Well, we won't ask the treasurer to come in and explain. But we don't want their taxes to go up
No.
because we've mischaracterized it here either. Okay,
Let's
go
with
ahead.
9.477, yep. All right, so, and that with the road setback and the terrain dropping off, and that we do believe that there is an unnecessary hardship to be able to build in a reasonable area on the lot. And of course, any sheds and sewer systems would also have to be within that area. As far as the spirit of the ordinance, the applicant's application and that for the reduced setback would not damage the rights of any other property owners or property values of anyone else in the area. Again, they intend to keep that easement access open and available to the south for the DNR property. And I think we've demonstrated that if they did have to comply with the 50-foot setback from the road, that would basically make it unbuildable on that parcel. So then I'm going to jump down to the final conclusion that we would suggest approval of the variance from 50 feet to 10 feet of the right-of-way for the creation of a principal building at 1436 112th Street in the town of Richmond with the following conditions. And basically that they follow the plans, comply with all the other standards, and that the new home shall be placed. I think that condition needs to be struck. I don't think 200th Street is anywhere around here. And then the screening and the sanitary and all other applicable laws are followed, and then the last two provisions are normal provisions.
I didn't think of this before, but I assumed that the house footprint was a typical size, so I didn't make a record of that. I suppose if it were a 100,000 square foot house, then that we might have to take a harder look at this. But from what you know, that sketch that you were given, did that, Mike, did that show a house of typical size for this county?
Yeah, it certainly does. It's again, they're kind of limited on site area that it makes sense to work with. You know, if you were to extend your footprint towards the pond, that could be done to some degree, but you start to slope down
Yep,
towards
I
that
get the point, but as long
non-navigable.
as it's a modest size, normal house, then it's best positioned to be between the steep slopes and the proximity to the pond versus the proximity to the road. Okay, we got the record covered there, I guess.
Okay.
Board members, any back and forth with regard to the writing of this? I guess we've got a couple of typos to correct, unless you want to come at it from some other direction here. If you don't, who wants the honor and glory of making the motion this time?
I'll make a motion, we approve this with the typo corrections as discussed.
Thank you, Mr. Miller. Is there a second?
I'll second it.
Mr. Nickum? Yeah. Further discussion? Amendments to offer? None of the above? Yes, sir.
I agree with everything these gentlemen have said, and I agree with the staff. And I think that that was explained about why these signs were there, because it's the end of a cul-de-sac. And I knocked on the door, and you have good watchdogs.
Did they come and lick you? I mean, that might not be because of the dogs. It might have been because of the gravy spilled on your shoes. You stirred them up. Okay. I think we're ready to vote. All in favor, vote aye. Aye. And opposed, nay. That's unanimously approved then. So if you can make those typo corrections before I leave, I'll sign these decision documents today. Otherwise, we'll do it when next we can get around to it. Thanks everybody for being here and being cordial, not raising any fist fights or controversies. Have a good day.
Thank you all. For the Board of Adjustment, I just note, just for your interest, sitting in the back, we have Colton Gosso-Brown, who's our newest staff member in our land use division, and he helped out with this variance request for the Bauer property. And also Julie Weber, Assistant Corporation Counsel, sitting back in the corner as well, who's been helping us with legal issues related to land use matters. So just recognize both of them.
Well, that's great. And of course, we're especially honored to have Christine Hines today here. Wow. I mean, come up in the world. We'll want to talk a little bit about future meetings in a moment, but I do want to give Mr. Nickum a minute here for some personal business that affects us all quite significantly. Microphone, please.
I have given Mr. Malik my resignation, along with Mr. Cheeza and Mr. Witt. And I was losing blood, and so I went to the Baldwin Hospital, and they did a CT scan. And I have bladder cancer and kidney cancer.
Oh, goodness. Wow.
So on the 2nd of this month, they did surgery and removed the tumor in my bladder. And the kidney, they're just not sure exactly what, they haven't made a decision on what they're gonna do. For the time being, I guess they're just gonna watch it. And then I have till the 14th of July to heal up, and then I start chemotherapy. And so in light of that, I thought it was time for me. I resigned from the planning board for the town of Baldwin. And for the 9-10 years I've been on here, I have learned a lot. It's been interesting, and it was a privilege to serve. I know that I ask a lot of questions, but I think it's interesting sometimes. I work for the county for 28 years, and so there's things come up like talking about the water. And when you mentioned about navigable waterways, sometimes I think rules and regulations are more about government power than we're worried about the waterways, and they're a little mud puddle. But I don't know that for a fact. That's just my mouth. And we do wonder sometimes about regulations, but I know that from working at the county that people would build their house in the middle of the road if you let them. So there are rules are necessary. There's no doubt about it. But it's been a privilege to work with the board members, with each one of you, and with this county staff. And it's been a treat. Challenging, but a treat. So that's all I have to say.
Well, on behalf, feel free to say your own words, members, but certainly speaking for myself and on behalf of the board, I want to thank you for your service, Dave. It's been great. At times we've had huge amounts of homework, and you've managed to plow through it and you know, sometimes ferret out a question that needed to be asked, and that's appropriate. On those rare occasions where you'd make a trip to Nashville to visit your family or something and you miss one of our meetings, we'd notice that you weren't here. I mean, it would be, your absence would be noticed. 9 or 10 years of service is a significant period. That's a lot of meetings. That's a lot of trips here from Baldwin. That's a lot of files. That's a lot of pages of homework read. That's a lot of sometimes frightened constituents out there, sometimes angry constituents. And you have shown a type of demeanor that's appropriate for this, you know, a kind of a resilience and ability to hear all sides and weigh them without excitement, without being drawn into the fray, as it were. I appreciate that. I'm sure the board does. The county is definitely in your debt for your service.
Well, thank you.
Dave, we'll miss your expertise and smiling face, and I know with all the other things you've done, you also found time to work for Gideon's. Rest assured that you're going to be in my prayers.
Thank you.
Mr. Cheese, and Ms. Hines, could you encourage Ken and the board for us to do some sort of recognition of Mr. Nickham's service? Maybe, some kind of certificate suitable for framing, or some kind of recognition at a board meeting, whatever. A decade of $90 for a day or less when the per diem was less is, it's small compensation for the amount of homework and sometimes the excitement that is involved in this board. Let's talk about meetings. Are we going to have a July meeting?
Thank you, Mr. Chair. Yes, we do have one variance application for July, so we do plan on meeting on the normal scheduled day. Be the 24th of July.
Thanks. I'm putting it down. Riverfest is going on that week. But there's nothing until 6 p.m., I guess, so I can't very well encourage you to stay around until 6 p.m. for the concert down at Lakefront Park. And I do hope that one variance doesn't take till 5 p.m. or whatever. But if it does, it will. We'll deal with it. We'll be at 8:30 again. Is that working out for you, Mr. Telejohn?
That works out. Of course, I'd like 8 o'clock.
You just need to talk the county into opening the building earlier or something like that?
Just like early morning meetings.
Yeah.
Get them done.
I suppose if you know anybody to recommend to Ken Witt for your replacement, Dave, you know what it takes to do this job, and if you have any suggested names, give them to Julie or Jason or somebody.
Okay.
Yep.
Anything else to talk about before we leave?
I've got a couple announcements for you.
Yes, sir.
We, as St. Croix County, submitted an amended Chapter 17 St. Croix ordinance to the DNR for their review. We found out yesterday that Kay Lutz with the DNR is retiring, and also Dale Resbeck. So basically, the shoreline program at the DNR is down to one FTE, which would be Susan Vanden Langenberg. So we're anticipating that review of Chapter 17 will be delayed a little bit. We're also in the process of working on an amended Chapter 16, which is the shoreline ordinance, and hopefully that'll go to committee here in July, but if not, it'll be in August, just because of their agendas are getting pretty full lately with the solar and stuff. So that's all I've got, Mr. Chair.
It occurs to me that you might consider as a workflow matter something that the courts do almost all the time. That is, they ask the litigants before them, the plaintiff and the defendant, to draft a proposed order the way they would like to see it. I'm thinking that with Sue Vanden Langenberg being spread even thinner, you might consider drafting what you'd like her to send us. Am I making any sense at all? I mean, you know the factors that she goes through. We've got examples that could be used as a template of her previous letters to us. And so when you send her our file, as you do at least 30 days before the hearing date, you could send her a proposed letter for her to send back to us. And she, of course, would make the decision she's going to make, but you might expedite getting something that you then don't have to argue as much about after you get it back from her. And in variance cases in the Riverway, of course, you need her approval. So we can't afford for it not to be here on the day of our hearing.
Correct. And so we've actually asked the DNR to provide those suggestions or comments ahead before we even publish the hearing and stuff. They have not been so receptive to that idea. But she did provide us guidance on what she wants in an email, as far as more technical assistance, just being very thorough with what we send and stuff, so she
Yeah, I
has
saw that.
provided guidance.
I didn't think it was particularly helpful, honestly.
As just as an example, I'm anticipating the board may see another application from David Swanson, Mr. Swanson, who he withdrew his request for reconstructing, expanding a dwelling up in Holton area and St. Joe, and so I expect we'd see that. It would be helpful, and I have referred in a preliminary form what he's provided to me to Susan Langenberg to try to get some feedback, but under current circumstances with staffing, I haven't heard anything as of yet. So it may be that he submits a formal application and we make a formal request for referral and public hearing notice to DNR on that one. But so yeah, we're trying to get those communications. In my mind, we could try the route of preparing what we'd like for a response. Ms. Langenberg is very detail-oriented, though, so I suspect if we did that, we'd have to be very detail-oriented.
Yeah, but that's not new to you. I mean,
Yeah.
you've dealt with those details all your professional life.
Yeah, of course.
Well, all that said, again, we're going to miss you, Dave, and we're going to be thinking of you and wishing you the very best.
Thank you.
With that, I'll declare the meeting adjourned. It's 9:57.